Good evening. Welcome to the Hyannis Main Street Waterfront Historic District Appeals Committee. Got to read some information and we'll get started. To all persons deemed interested or affected by the town of Barnstable's Hyannis Main Street Waterfront Historic District Appeals Committee under Chapter 112, Article 3 of the Code of the Town of Barnstable, you are hereby notified that a public hearing is being held via remote participation methods at 6:00 p.m. on Tuesday, March 26, 2024. Alternative public access to this meeting shall be provided in the following manner. 1. Real-time access to the Hyannis Main Street Waterfront District Appeals Committee meeting is available utilizing the Zoom link or telephone number and meeting ID provided below. Public comment can be addressed to the Hyannis Main Street Waterfront Historic District Appeals Committee utilizing the Zoom link or telephone number and meeting ID provided below. Phone 888-475-4499, meeting ID 830-9508-8240. 2. Applicants, their representatives, and individuals required or entitled to appear before the Hyannis Main Street Waterfront Historic District Appeals Committee may appear remotely and are not permitted to be physically present at the meeting and may participate through the link or telephone number provided above. Documentary exhibits and/or visual presentations should be submitted in advance of the meeting so that they may be displayed for remote public access viewing. Notice of recording. Please note that this meeting will be recorded and broadcast on Channel 8 or High Definition Channel 1072. It may also be accessed via the Government Access Channel live stream at the Town of Barnstable website. Okay, I'd like to call this meeting to order, and we'll start with the roll call. So I'm Allison Alessi, I'm present.
Aaron Webb, present.
Okay, so we have one item of new business this evening. We are reviewing appeal number 2024-01. Zero School Street LLC have appealed the decision of the Hyannis Main Street Waterfront Historic District Commission to approve the applicant's request, Shoestring Properties LLC, for a certificate of appropriateness for the proposed construction for 2 new buildings for residential condominiums. The subject properties are located at 110 and 115 School Street, Hyannis, as shown on Assessor's Map 326, parcels 121 and 125. Okay, so I need a motion to open the appeal.
So moved.
And a second. I second it. And then we need to vote and say our names because we're on Zoom.
All right, I'm in favor. Aaron Webb.
I'm in favor. Allison Alessi. Okay, and I think we have a quick staff report or handout.
Yeah, good evening, Jim Kupfer, Assistant Director of Planning and Development. I just quickly wanted to read in the purpose and authority of the Appeals Committee, as well as the criteria of the commission in which you're charged with reviewing. So any person or persons aggrieved by a determination of the Hyannis Historic Commission or by its failure to act as specified in this article may, within 20 calendar days after the filing of such notice with the town clerk, appeal to the committee in writing. The committee shall hear all pertinent evidence and act upon such appeals within 30 calendar days after filing of each of such appeal. So before I move further with that, just want to reiterate. So the commission rendered a decision, a certificate of appropriateness. The direct abutter has appealed and has done so within the 20 calendar days. This committee reviewing the commission's decision has opened their hearing just now within the 30 calendar days. So the committee shall hear all pertinent evidence and act upon within 30 days. The decision of the committee, this committee, shall be determined by majority vote of the committee members. If they determine that the commission, the original historic commission, action is unsupported by evidence or exceeds the authority of the commission, they may annul the commission's decision or remand the case for further action by the commission. The findings of the committee shall be binding on the applicant and the commission unless a further appeal is sought in Superior Court. So tonight, this committee, this appeals committee, is reviewing the actions of the commission, not necessarily the project, the commission's action and whether it is unsupported by evidence or the commission has exceeded their authority. And so quickly, I just wanted to read in the criteria for the commission The commission, in the case of new construction or additions to existing buildings or structures, the commission shall consider the appropriateness of size, shape, and location of buildings or structures, both in relation to the land area upon which the building or structure is situated and to the building structures and general setting in the vicinity. So that's the criteria for new construction for the commission. And they've rendered a certificate of appropriateness. That certificate of appropriateness was stamped in with the town clerk, on February 21st. And an appeal was stamped in with the clerk on March 1st. So this committee tonight is tasked with the charge of reviewing what the appellant has to present to you and to determine whether the commission was supported by evidence in their decision rendering that certificate of appropriateness and did not exceed their authority. And with that, I know the committee members have the links to the meetings, and they also have the minutes and all the documentation that was provided by the applicant originally when submitted to the commission for their 2 hearings. And with that, I'll hand it back to the chair.
Thank you. I think at this time, we're going to have the appellant provide any further evidence, but I do want to reiterate that we have watched the 2 meetings and we have all the materials that have been presented at those meetings. So I would encourage the presentations to focus on the specifics of the appeal.
I intend to do so. And for the record, David Lawler as the attorney for the appellant. I'm just going to refer to them as Dockside Marina for purposes of ease. I do want to note, and just in the verbal record, incorporate the documents that I submitted, which would include an area map from the town website, or 2 of them, the applicant's application itself, the minutes, which obviously are part of the record anyway, and with respect to a site plan that I submit was not submitted by the applicant. And I, for the record, state that, the decision of the board was not supported by the evidence and it exceeded its authority. Moreover, it was legally untenable ground. It was based on legally untenable grounds, unreasonable, whimsical, capricious, and arbitrary. And I believe that this board should find so. If you having reviewed the lengthy discussions in this matter, I'm just going to shut the door. Hold on one second. Thank you. If you review the minutes, but also the hearings, which you've indicated that you have, there was tremendous discussion based upon items that are completely outside the purview of the Historic Commission: parking, a need to upscale the neighborhood, trash locations, and these items. And what was not discussed was the size of these particular buildings submitted by as they fit into the historic district, the waterfront district. If you look at, I don't know, Jim, could you pull up those maps? You can just pull up one. I think that would be sufficient.
I'll check with the chair if she's comfortable with pulling up the documents that Attorney Lawler submitted.
I think it's okay to share a document. Is this the one that we just received a few minutes ago?
Yes.
Okay.
I'm not gonna pull them all up. I'm just gonna pull probably only 2 up.
It would be
Just a minute.
helpful if we did receive these documents more timely fashion. It's
I
not fair
apologize.
that we didn't have a chance to look at those, so I'll allow you to present them, but please know that we haven't reviewed these in advance. And
I apologize. I've been out straight, and that's my fault. Okay, there's another one which is just a little larger scale of it. But this is a property map from the town website, and it's primarily to scale and not completely. But if you look just in general, the buildings in these particular lots, and certainly when it comes to the combined uses is that there's always a building and then a substantial amount of real estate that is not occupied by a structure. Some of them, like for instance, the steamship, do have a tremendous amount of asphalt. Some of them have backyards and just grassy areas, but virtually actually not virtually, none of the buildings encompass the amount of the lot, or certainly virtually none of them have the percentage of lot coverage and massing on the lot itself, or in the case of, again, the steamship, there are multiple lots, but they all access the same, and for purposes of their uses have merged. And it's just not there. And I'm suggesting you that with respect to this applicant, the board did not consider how these structures, and if you could pull up, if you might, Jim, the colored photograph of that I submitted, the one-page document showing that the site plan with the buildings on them. And if you look at these particular photographs and you compare them to the ones you just looked at, these are the two proposed buildings as they sit on in the lot. Both buildings at the lower water side, I believe both, but I'm certain that the larger one is within conservation jurisdiction. But the structures themselves take up a massive amount of the lot, well in excess of 50%. And and just surrounded by a little green ribbon on either side with no functional uses on the land. Now there is parking underneath, which I'm not going to get into. I'm not going to get into parking and those issues because that's not in the purview of the board. But what I'm suggesting you, if you look at the minutes, if you look at the hearing, they did not apply the law. And as Mr. Cuthbert said, Chapter 112, 32, subsection small b, in the case of new construction or additions to existing buildings or structures, the commission shall consider the appropriateness of the size, shape, and location of the building or structure, both in relation to the land area upon which the building or structure is situated, and to building structures in the general setting and in the vicinity. And this was not done. This was not applied by the board, and based on that analysis, it should be denied. And that again, I'm not going to, you've seen the evidence. This isn't a hearing where I'm going before a board. This is a different standard. There's not witnesses or things of that nature. So I'm going to rely on the documents submitted that the applicant did not provide within its application, a document to the board that showed how big the building sat on that individual lot and how that was in relation to that lot. The applicant did not provide that. And the discussion and the minutes did not reflect that this board weighed that information in rendering its decision. And as such, I believe that, based upon the standards provided and the evidence provided, that the board did not fully take into consideration Section 112, and which it had to. And as such, the decision was not supported by the evidence. They were arbitrary and capricious, whimsical, and it was based on an unreasonable decision and legally untenable grounds. I'm not going to go any further. This board understands the law. They understand the provisions in my argument. It's a very limited argument, and I submit that. And Jim Cuthbert does not believe how quick I was.
Okay, thank you. I think at this time, we're going to offer a chance for the original applicant to, again, rebut what we've just heard, not represent the whole application. Again, we've seen the two meetings, so I'll give you an opportunity to rebut what was just said.
Michael Princey for the applicant. Dan, are you in? I can't tell. Yes, President accounted for, and I'd love to just say a few words very briefly after you.
I don't think the witnesses are, I think this is more a legal argument. This is an appeal. I would object to that.
Well, it's a direct rebuttal to your
Well,
misinformation.
but it's represented by counsel, and I believe that this is an appeal, and this is not witnesses under sworn statement, and this is a legal matter and should be presented by an attorney.
I would defer to the chairman that she asks, the applicant's represented by myself and Dan Ojala, and I think you've raised as a legal argument as to the size, and Dan is going to give the response to that.
Yeah, I'll allow that. I think there were some questions in there that could be answered by an engineer.
Okay, I object for the record. Thank you.
Thank you.
With the board's permission, so I would strongly object to the characterization that the commission did not carefully weigh the massing and the area and the size and the height. These things were discussed very carefully and vetted in prior applications, which were approved, and then we was asked that we reapply with a much shorter building, and we talked about all the same things. The cover sheet shows the same map that Mr. Lawler just brought up. It shows the vast parking lots directly adjacent to the building that are the steamship authorities. So if you're looking for big open spaces, you need only look to our west, to our south. Kirker's got a large parking lot directly adjacent to ours. So while our cars are hidden underneath and tidy, what Mr. Lawler says is that many of these buildings have big open spaces next to them. Well, very often in downtown Hyannis, those are parking lots. And what we've done is very tightly tucked our parking underneath the building. And I would submit that if you look at the set of plans, it very clearly shows perspective views, it shows massing, it shows the project area, it shows a locus map, and is very descriptive. And the overview shows all the parking around us, all the open spaces that will remain. And again, we've provided a full 20-foot front buffer, and where 10 foot is required. And we've met the conservation buffer regulations in spades. I really don't think that, I think it was carefully vetted and considered, and I wouldn't say that this was at all capricious or arbitrary. It was very carefully vetted, explained, discussed, and weighed upon, I feel, correctly.
And I will briefly add to that I think in Dan's calculations that in all respects, the building and the layout of the buildings on the site met current zoning requirements, that it's slightly less than the 75% lot coverage. And I think that the commission, having reviewed this on a number of occasions prior in time when the applicant was somewhat more aggressive in terms of looking for some zoning relief, he's brought it back based upon guidelines set by the commission and by the town and suggested by site plan to bring in a proposal that did in all respects conform to the zoning bylaw. It meets all of the design requirements. We have 5 affordable units that are going to be going in there. And in my review of the proceedings, which both members of this committee has or will review, you'll see that all of this was vetted. So to the extent that there's any suggestion that a unanimous vote by your historical commission in any way did not take into account all of the information that they were required to take into account under section 112.32, I think that's attempting to be misleading towards you. And I think you can see just from reading the minutes of the meeting and viewing the meeting that this board took considerable time, listened carefully to all the arguments, including Mr. Lawler's, and made the appropriate decision at this point, at this juncture, on this plan to approve it and have it move forward. I don't think there's anything more to be said since this is such a limited argument against the unanimous vote. I think that, again, having reviewed the materials, I think you'll see that we have in all respects complied, and the commission did its task and carried out its task under the Enabling Act and under the local bylaw. As you know, I submitted this afternoon just a brief 2-page letter summarizing some of the criteria that goes into this. I had anticipated a broader presentation by the appellant, but it did not occur. So in light of that, I'm concluding. Thank you.
Thank you. I think, are there any questions, Aaron, that you have or I have for the applicant? If not, we
this
can
time, I
move on.
don't.
I think I want to give open this up for public comment. We have other members on or other folks on the Zoom, and I want to give them a chance to also speak if you don't have questions.
I'm just curious on the this procedural hearing is subject to public comment. I don't.
If I may,
But well-
if the chair wishes to have any public comment or anything that can support the stance, you may consider it. But again, it is a very narrowed hearing. And sorry, I'm just looking up the exact language here. So it wouldn't be argument or anything in support or against the project in and of itself. It's simply whether the commission met their the requirements and did not exceed their authority.
And I again would object to public comment. I don't believe it's appropriate for this type of.
We've had public comment the whole time I've been a chair of this committee, so we're going to allow that. But again, I'm going to ask, as Jim just mentioned, to please focus your comment on the specific matter at hand. We've seen the public hearings.
Okay, and just note that for the record, my objection.
Thank you. Okay.
Well, I see a hand from, I believe, Mr. Carey.
Yes, go ahead.
Okay. All right. Two things very quick. I was at the hearing. They spent a lot of time, probably an hour, talking about the size. It was very carefully considered. And actually, there was a very interesting concept developed, which was, can a commission, which doesn't have the legal power of the building department, actually override the building department's rights, which includes size, established in that zone? But that's for people above my pay grade to decide. What I wanted to tell you is that you are being used, you're being used as a tool. This is a grudge match. This is not a substantial issue.
Motion to strike.
This is a grudge match between two people. You're being used as a tool. Strike me. It's okay. Maybe it's an uncalled for observation, but it is true.
Okay.
Take care.
Thank you. Does anyone else have a comment they would like to make?
Not seeing any further.
Okay. Okay, now we have an opportunity to deliberate. So Aaron, you didn't have any questions. Is there anything you wanted to add to the conversation?
There really is not. I mean, after both reviewing both hearings on the in January and both the secondly this February 7th meeting, reviewing the minutes and the materials provided, I do believe that the commission acted within their purview and within their jurisdiction to grant the appropriateness. And they did deliberate at times. I do agree with Attorney Lawler that there were also times when they might have gotten astray, but it was brief and it wasn't the really the nemesis or the crux of the conversation. They talked about architectural designs, concepts, windows, lighting, things that I think they were charged to look at. So I do believe that they spent 2 hearings and countless hours, reviewing the materials provided by by Shoestring, and voted, as best they could, given the materials that they were presented, and both arguments from the applicant at the time, as well as public comment and the abutters' concerns. So I think they were, I think they were charged with a task, and I think they did the best they could under the circumstances. And I see no reason why our appeals committee would voluntarily or charge to overturn the decision.
Thank you. No, I agree.
That's my
In watching the 2 hearings, I felt like there was quite a bit of discussion about the size of the building and kind of the struggle to understand the buildings around there, and kind of understanding back and forth, oh, this one's out of the district. For example, the hospital, there was quite a bit of talk about the size of the hospital. And while you see it in that context, it's outside of the district. So I believe there was quite a bit of time spent considering the scale of the project and the lot coverage. And even though lot coverage is more of a zoning construct, I do think they spent a bit of time sort of looking at that site plan and understanding the coverage and how that related to other buildings around the area. So I agree that I think I don't think we have grounds to I think we can support their decision. I think that my inclination is to uphold the committee's decision.
Yeah, and I would follow up real quick with just that I felt like, the conversations regarding parking, although maybe not under their purview, does relate to how does this project fit within the neighborhood and so forth. And the density, I know that word was used multiple times, the massing, just the scale of the project. And, I really think they took all those factors into consideration, and you have to look in some ways at the project as a whole, I think, when you're determining whether or not it does fit within the parameters of what they were sort of charged to do. And I think they used the evidence provided to the best of their ability, like I said, and made the right decision.
Okay. So I think what we need now is a motion. Do we need to close the public portion, Jim? I'm sorry.
Yeah, you certainly, to be clean about it, I would motion to close the public hearing and second, and all in favor with a roll call.
Okay. I move to close the public comment section of this meeting.
Second.
All in favor?
Aye.
Aye, Allison Alessi. Okay,
Aaron Webster. Yep, go ahead.
thank you.
Sorry.
Okay, Aaron, can I ask for a motion?
Yeah, once I'm just looking for the, sorry, I'm just looking
Yep.
for the agenda here. Got a couple different screens working. So we close public comment. So am I reading the motion to uphold at this point?
Yes.
All right, I make a motion, please, to uphold the approval decision for certificate of appropriateness for 110 and 115 School Street.
I
Need a
second.
second. All right. And then all in favor?
Yeah.
Oh, go ahead. You go first.
All in favor?
I, Aaron Webb, say yes.
I, Allison Alessi, say yes.
I would like to thank the appeals committee for your time and consideration, even though it didn't go my way. I really appreciate your efforts. Thank you so much.
Thank you.
Thanks, David.
Thank you on behalf of the appellee. Thanks.
This is Stuart too. Thank you very much for your time. Greatly appreciate it.
Okay, I think we need a motion to adjourn.
Sorry about that. I'll make a motion to adjourn.
No problem. I second.
All right, all in favor? Aaron Webb, I'm in favor of adjourning.
Allison Alessi, I'm also in favor of adjourning.